Hello, everybody. Oh, I have to get my little chat up. I forget about that part. Um, I wanted to come by today and just talk about two new filings that have come up since we were talking the last time about court documents. So I'm just going to pull up my little chat here. Cool. Nobody's here yet. Love that. Oh, nope. Someone is here. Just kidding. Hi. Oh, hey, everyone. Okay, people are here. All right. So my numbers just aren't updating. Hey, Monica, Kathy. Okay. So what I wanted to do was go through the two. They're not even new. I don't want anyone to be like, oh, new. They're not that new. What's today? Like the 30th? One was filed. Well, I guess one was filed yesterday, so maybe. But I just wanted to do like a check-in. I haven't really been around since, the book club thing on Thursday, Through the Storm Thursdays, which was a hit and a success and so fun. But I did want to just come by, like hang out with y'all, check in. That's one reason. Another reason is the second document we're going to get into is really weird and I have not read it. So it's going to be like a serious live reaction here. Hey everyone. Hey. Okay. So this first one is just a couple pages. And I just felt like since we're coming on here anyway, like I'll go ahead and do it. It is the letters of conservatorship from Jody Montgomery's lawyer, Lorianne Wright. And she is correcting them to make it the conservatorship of the person. And then they kind of get into what her powers are, right? And what are her... Oh, Sloan is here. Oh man, I'm in the presence of a royalty. Where's Sloan? I don't see him. Oh, hey, Sloan. I love Sloan. Y'all should go watch Sloan's channel if you don't. Okay. All right. So what are the powers of a conservator, right? We already know this, but I did want to just run through them real quick here. Did Britney's hometown of Kentwood get hit by Ida? I actually don't know. My personal hometown does not have electricity though right now, but all my family is safe. They are just having hurricane snacks and hurricane parties and days off school and work. So they are safe. My personal family, thank God. Okay. So the temporary conservator of the person, that's Jody. She's technically the temporary conservator, is granted the same powers that she previously was granted. Letter A says the temporary conservator shall have the power to restrict and limit visitors by any means. Okay, so Jody has the power to restrict and limit visitors by any means, as long as she doesn't prevent her from meeting with her attorney, Matthew Rosengart, except to approve the location for any meetings or visits, and for arrange appropriate security. Well, Jody needs to figure out her own security, sounds like. Okay. B says the temporary conservator shall have the power to retain caretakers for handlers for the conservatee on a 24-hour, 7-day-a-week basis, the power to retain security guards for her, and she shall have the power to prosecute civil harassment, like restraining orders. And D says she shall have the power to communicate with treating and other medical personnel and to have access with any and all records regarding her treatment, diagnosis, and testing, and Jody can have access to any and all records regarding psychiatric treatment, diagnosis, and testing. But what you'll notice is missing from that bottom paragraph is the ability to actually choose Britney's doctors or make medical decisions for her. A lot of people think, and even I thought, right, at the beginning of when they get into the movement, that Jody Montgomery or that Jamie Spears or whoever has the authority to make these medical decisions for her. That is not the case. She never lost the right to make her own medical decisions. And so while I do think it is a bit ridiculous that Jody Montgomery has all these powers in paragraph D, I don't see it saying that she has the authority to make medical decisions for Britney. And so it just does call back into question the whole IUD thing that happened in court, right? So that is like all that there really is on that one that I really wanted to talk about. Now, there's another filing, which is the title of this video, that, y'all are so nice, that was filed. When was it filed? the 26th, though, like a few days ago. It's not like a brand new breaking news or anything. But I do think it's interesting because this lawsuit, and we're probably not going to get into the whole thing today just because, spoiler alert, it's 244 pages long. So I did want to just kind of get a taste, though, of what in the hell, right? Because what it is a media request, right? And it's usually like a media request to broadcast or photograph, record, or broadcast. And they're usually like a page, 2 page, 5 page. Like the fact that this is 200 pages long, like I don't know what we're about to get into in here. This is going to be a Britney Spears deep cut. And so, you know, get a cup of coffee, roll whatever thing your herbs you're currently using, and you know, to buckle up. So it was filed. Let's see. Let me make sure it's in y'all's like actual view here. Okay. So this was filed, as you can see, on August 26th. Today is like the 30th or something. What is today? 30th or 31st? I don't know. So this was filed quite a while back. We have Christopher C. Melcher is the person who's filing it, and actually never knew he was the attorney for USA Today. I could have probably very easily figured that out. It wasn't like it was some big secret. But he's in the Free Britney movement. He also posts videos and stuff. So I've never read one of these before. Usually I'm not trying to waste my money. Like I paid $40 for I paid $40 for this document. Or more because it's so long. Okay, so attorney for petitioner, USA Today, a division of Gannett Satellite Information Network. Okay, so then we're gonna have him giving his table of authorities, and like essentially we could probably get the gist of the lawsuit if we just read this page. So what does it say? Okay, so there's introduction. There's a relief requested, statement of facts, and then his discussion, which usually means like, what's your legal argument? Yeah, it's weird that it's this many pages for a legal request. Okay, so the argument is the First Amendment and the California Constitution provide a right for the public and media to attend non-confidential court proceedings, including probate conservatorship cases, and that is also my legal understanding as well. Probate conservatorships are generally governed by the rules for civil actions, okay? Any closure, other than for confidential matters, does not pass the historical tradition. So there's like some test. And then he says case law for LPS conservatorships is inapplicable. Now, a lot of people know this already, but there's two types of conservatorships in, I'll put like a PayPal or a Square Cash up in my video description later for those of y'all who are asking. Will be forgotten. You'll be on top of a firm. So, well, I don't know if I want to work for a firm again because that was not a good experience. But okay, so in California, there's two different types of conservatorships. There's like a thing called mental health conservatorship, also known as an LPS Act conservatorship. And then there's a probate conservatorship. Now, it's kind of difficult to tease these two apart. And California is one of the only states that actually differentiates because it really is just supposed to be a standard of like, can you take care of yourself or not? You know what I mean? But a lot of times you see people using cases from these other type of conservatorships, LPS, and that is not what Britney is in. They actually lied to the court and said Britney had dementia in 2008. And so she's not in a mental health conservatorship. People think, you know, she's in it for bipolar or ADD or something. Like, no, she's in this conservatorship because they lied and said she had dementia. Oh, Monica, you're so nice. Thank you for the, well, okay. Well, I guess Monica bought this court. Oh, that's so nice. Thank you. Oh, that's really sweet, Monica. You the best. Okay. So a lot of times people try to think, you know, this is Britney's in because it's bipolar or something. That's not true. That is not true. The court documents say she is in it because they lied and said that she had dementia. I mean, they never gave proof for that. Okay, so basically this lawyer is going to argue, and we're probably not going to go through this whole thing today. Y'all would take me like 5 hours to do it. But if y'all like this part one, we can finish it later. But I think it's important that he is going to be arguing, you know what, all those cases with LPS Act, that's a totally different situation. This is not an LPS conservatorship. So that's the one that we need to be liking. That's the one we need to be making analogy to this case too is the probate conservators, not the LPS. Okay. So then the second argument will be termination of that remote audio access program violated the free speech rights of the public and media under our federal and state constitutions. Now, the remote audio access program was the program that allowed us to actually hear Britney speak in court on June 23rd. And very shortly after, I want to say it was within a week, after Britney spoke in court on June 23rd, the court decided they no longer wanted to make those hearings be broadcast. And so this, oh, thank you, Martini. Love you. Death to all of them. Exactly. Thank you, Martini. That is so nice. Y'all are gonna pay for all the documents just with this stream here. Okay. So basically they're going to argue here. Christopher Melcher, attorney, is going to argue that terminating that program was actually unconstitutional. Now, I just listen, devil's advocate, benefit, like I'm going to read it all. I want to read his argument, but oh shoot. Oh God, there went all my markers. Oh my word. This is what you get when you go live. Oh, hi Nicole. Thank you. My little expo markers. Does anybody else have to write in like every color? Okay. So in my opinion, I think that from what I understand, the remote audio access program was put in place for COVID, and there were no more COVID measures being taken at the courthouse. And that's why they took away the remote audio access program. Now, I am very interested in hearing Christopher's argument on this. Maybe we'll do like that section in its own video or something. He says no compelling government interest exists in preventing the recording or broadcasting of those proceedings. And he's saying eliminating that program was an overly broad reaction that infringed upon the right of the public and media to access the court. Now, what I'm going to be looking for in there, Christopher, is you mentioning some type of COVID restrictions, because I believe that's why it was implemented in the first place. But I mean, listen, there's a lot of info here that we can, gather on. And then they do the conclusion, and then they do a declaration of someone named Maria Puente and request for judicial notice. I have no idea what we're about to read. I have no idea what we're about to stumble across. We're literally doing this live in real life together. I think the death to all of them is a reference to the Wendy Williams show. I am, for the record, not actually wishing death on anyone. And I don't think anyone else should do so either. Okay. So introduction, Los Angeles court allowed the public and media to listen to non-confidential proceedings through this program. And we're going to call it RAP. Okay. And canceled the program a day after a few people broke the rule against recording. Well, okay, Christopher. Okay, listen, I just want to preface this with, I really like Christopher a lot, but I like to be like fair and balanced or whatever, but like actually, so I just want to say like, yes, a few people did break the rule against recording, and it was an overly broad reaction. I completely agree, but like millions and millions of people heard those recordings. So it wasn't like, okay, just a couple people. It was like millions of people heard it, but I've always said, you can go back and watch those videos I made around that time, that, yes, this was filed in Britney's case. Oh, thank you, piece of me. Love your dedication. Do you think Britney will be free by the end of this year? Ooh, good question. Is it Pisces of me? I don't know if Britney will be free by the end of this year. At first I was thinking yes, but I mean, Matthew Rosengart's moving a little bit slow for that. Again, listen, I know he has a strategy. I know he has a plan, all that. But hopefully, I mean, I'm thinking it's probably going to be more like an 18 months thing, but we really literally have no idea. Jamie should answer for what he has done. Thank you so much. I think it's pieces of me, but I'm not a good reader, so maybe that's Pisces of me. Not sure. Thank y'all so much. So nice. Okay. So essentially what I'm going to be looking for here is him to reference the COVID thing, right? And maybe I'm mistaken. Maybe it wasn't just for COVID. Maybe this has always been going on, right? Who knows what's in the media these days? So let's just see. So it says canceled the program a day after a few people broke the rule against recording. The court now requires in-person attendance for the public and media to monitor and report on what happens in court while granting video and audio access to parties, counsel, witnesses, and other through another program called LA Court Connect. Okay. I was actually in the court on July 14th, and y'all, they took my phone, put it Oh, it is Pisces? Hey. Put it in this bag that like doesn't let you get signal to your phone or something, and like made us turn it off. And they said like if you don't turn your phone off, when you take your phone out of this bag, it could be dead. So I don't know if that's true or real or what. I'm not like a very good at technology things necessarily, but they took my phone, put it in this bag, and then locked it with this like special lock and gave it back to me and said, we'll unlock it after the court. So you really have to be sitting. There's no way that you're going to be able to use your phone in that courtroom. Now, what I found interesting was they only did that to the members of the public. People in the news had their phones out and they were looking at them and texting and stuff. So I thought that that was a little bit inappropriate of them to do. Yeah, true. I think she's pretty close to free already. I know y'all don't like when I read comments, but I just like talking to y'all. Okay. So Christopher says the court now requires in-person attendance. That is true. Okay. The termination of that program, so here's his legal argument, infringes on the right of free speech and fails to provide equal protection under the law. Now, I am seeing here these are federal rights, and I'm already anticipating that Mr. Melcher may be prepared to go to the federal courts with this if this particular judge, Penny, doesn't let him come in and do what he's trying to ask to do. So by taking away the right of the public and media to observe court proceedings remotely, but affording that right to others, the court created two classes. Good argument, Christopher. One that can access the courts remotely and another which cannot. So he's saying this is unconstitutional because only a certain amount of people can even go in that court. So what, you're going to make people line up? Because the public and media have a constitutional right to access these proceedings, the court must establish that terminating that was necessary to protect a compelling government interest and that its action was narrowly tailored to serve that interest. Now, if you're ever planning on going to law school, take a screenshot and highlight this sentence because it will be on your constitutional law final. This is so incredible to see stuff you learn in law school just keep repeating itself over and over. But there are certain tests that you have to sort of pass as the government or as a court in order to take people's rights away. Now, if you're going to take away people's rights to hear a court hearing, you have to have a certain amount of interest in that, right? Like, so if you're the government and you're going to take away the public's constitutional right to hear this court hearing, which it hasn't been established that the public has a right to the RAAP program, but let's just say that we do, then the court, by taking that away, has to say, here's our compelling government interest. And they're not going to have one. Oh, we want to cover up our crimes? Like, what are they going to say? Then he goes on to say the court's desire to prevent recording is important, but not compelling. Okay, so what Christopher is saying here is, if the court comes back and says they're trying to prevent recording, that is not a compelling reason. So go back to the drawing board with that. Wait. I like when you interact with the comment feed. It makes us feel special. I know, I like to, but like I keep getting comments on my other videos after they're posted. Like, can you not read the comments while you're doing it? It's distracting. And I'm like, but I like people. I don't want to talk to people. Okay, I'll just try to find a balance here. All right. Okay, so basically Christopher is saying, listen, if the court is going to come up and say, oh, their desire to keep people from being able to record is the reason, Chris is saying that's just not enough. It's just not going to, oh, thank you, R. Haley. Oh, keep up the great work. Thank you. Y'all are so nice. Thank you. The concern over recording does not override the need for transparency. Okay. He says it is paramount that the public trust and confidence has to be maintained in the judicial system by allowing the public and media to observe the proceedings firsthand. Less restrictive means were available. The court could have issued additional warnings or punished the violators. But eliminating the program for all members of the public and media instead is what they did. The risk of recording remains because those who use the LA Court Connect are just as capable of recording proceedings as the members of the public and media. There are limited seats in the courtroom, and we are still in a pandemic. Okay, Christopher, thank you. This is what I wanted to see. That he is going to bring up that we are in a pandemic. And it's just not fair. Like, what if someone has immunocompromised? What if someone hasn't been able to, for whatever reason, be vaccinated? Whatever. You know, like, I can think of a lot of reasons. I really don't want to get into all of it. But there's a lot of reasons why somebody might not be able to necessarily go to the courtroom. And, you know, maybe they should be. California is a huge state. So even citizens of California may live hours and hours away, and maybe they want to hear the court hearing. And listen, this thing was going on for like at least a year. I sat at this very desk and listened to many court hearings, 2 or 3, from that program. So it was really nice. So media outlets across the world are covering this story and other important cases in Los Angeles Superior Court, but they cannot send reporters to watch every case in person, especially those like USA Today, which is based outside of California. Even if the media had the budget to send reporters in person to these hearings, the court doesn't have the room, and there are health risks during the pandemic. This is what's going to really be your biggest saving grace argument here, Chris, because there's reasons people cannot use the court as in normal society, like before the pandemic, right? Let me see. Please keep recording. Please keep reading comments. I'll balance it out. I'll do it every few paragraphs. We'll see. And so Chris says, by taking away remote access and limiting public and media access to in-person courtroom attendance, the court has given preference to those who it allows to use the LA Court Connect and to local media outlets who can send reporters in person. The disparate treatment is an unconstitutional infringement on the rights of the public and the media. Okay, cool. So what's the relief requested? So Christopher is asking to restore the RAP program, whereby people can listen to the audio of the court in real time. Now, you could be in trouble if you record that. You're not supposed to record those things, but of course people do. Right, exactly. So Chicken Lip says they live an hour and a half away from the nearest county courthouse and they are disabled. And so they can only imagine how hard it must be for a lot of citizens. Exactly. Britney had the vaccine. Yeah. She said, she went on, Instagram and said she did. Okay. So Chris is asking to put that audio program back in place. Just as it existed before they canceled it on June 28th, 2021. Number 2, a link to the LA Court Connect for a limited number of the public and media to observe the proceedings. Okay, well, who's the limited number, though? I don't know what this means. Who's the limited number? Because again, Chris, I think you're kind of stepping onto the territory of creating an unfair situation again. Either everybody should be able to see it, or nobody except those in the courtroom should be able to see it. That's how I'm interpreting it. But I mean, you're the expert here. Okay, a link. Okay, the number of links may be determined by the court according to its technical capacity and should be honored on a first come, first served basis. I don't see how this, Christopher, is very different than what we're arguing against, though, right? So either the public can see LA Court Connect or not, because I really don't think a first come, first served basis. So what, like people with the fastest internet, people who have the expendable time to sit around and wait, who knows? You know what I mean? But maybe, listen, I don't know. This is just my thoughts. I'm not married to these ideas. At minimum, remote access without recording or broadcasting is requested through RAAP to the non-confidential portions of the hearing. Okay. So basically what he's saying is, okay, if you don't do number 1, which is restoring that first thing where we can all listen to it in real-time audio, and if you don't do this where you're allowing some of us to even see inside the courtroom through the LA Court Connect, then at the minimum, this is what Chris wants to see and USA Today wants to see on September 29th. They want the non-confidential portions of the hearing regarding the petition to suspend Jamie and to appoint a successor. He wants the portions regarding the hearing, regarding the 12th account and any final account to be open, and the request for security for Conservator Jody Montgomery. All other petition, authority, and appointment hearings not closed to the public in any continued hearings on such matters. Then he says, number 4, he also wants judicial notice of the matters identified, admission and evidence of the attached declaration, and finding on any denial. Okay. So I just wanted to read through that to see where we were going. So essentially, all of this right here is what he's really thinking is the most important, what he really wants to see from this upcoming hearing. That's going to be stuff relating to Jamie getting removed, a new conservator being appointed. That's going to be things having to do with the accounting, things having to do with Jody's security that she requested, and then like catch all for other stuff, right? Now, he's now referenced this declaration of Maria, maybe it's like Maria Puente. I do not know how to speak Spanish, but this is the second time that he has said this. So I'm really interested into seeing what exactly that declaration is. Okay, so now he's going to get into the facts section. Now, every single like legal brief is pretty much exactly the same sections. And the facts is just where they're going to tell you the facts. And all this stuff is probably going to be stuff we already know. Okay, let's see. What are y'all saying? Yo, 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 what up, party people? Hello. What about her medical records, custody discussions? Those would not be included. Could they say medical records will be in camera? They could say that, Jennifer. Why is recording not allowed? Great question. Great question. Who knows? A lot of these rules were put into place 100 years ago. Like, a lot of these rules were put into place a long time ago, and nobody's really ever questioned them again. I would want everyone to know the truth through me and not through second, third party. Everything gets mixed up. How much right does he have to any of this? That is a good question, Gutter Star McKenzie. So they ask, how much right does he have to any of this? And what I'm assuming you're asking is, how much right does this guy, Christopher Melcher, who's like USA Today's attorney, have to any of this? And as it turns out, he individually, as a member of the public and as a member of the media, has a First Amendment right to know what's going on in the court proceedings. So he actually does have a right. But Britney does not have dementia. Yeah, clearly she does not. How much did this filing cost? Oh my God, there's no telling. I'm going to have to get to the end of it to see exactly what is put in here, but there's really no telling how much it costs. There's no telling. I don't know how much like Christopher actually charges hourly. Maybe has reasonable rates, but this is like a pretty in-depth memo. So here's the facts. Okay. The court announced the creation, of that audio program on January 11th, 2021 as a way for attorneys and members of the public, including the news media, to listen remotely to non-confidential court proceedings throughout the Superior Court of Los Angeles County. The notice said the program was part of its effort to ensure public access during the pandemic due to social distancing requirements in courthouses. Another program, LA Court Connect, allows remote video and audio access to the court. The user guide states that it provides the video and audio services for remote appearances. Access is provided for probate proceedings. The court has waived a $15 cost recovery fee, so LACC users can participate for free. The court made clear that the LA Court Connect was not for the public and media because that access was provided through RAAP. Okay. This is actually, I see where you're going with this argument. I see where you're going. LA Court Connect is not available for use by the news or general public. The guide explains, spectators, anyone without a role in the hearing, may participate via RAAP, which enables users with a smartphone, tablet, or computer with internet service to establish a remote connection to the courtroom and listen to court proceedings. RAAP requires users to create a court ID and password, and then they have to register and all that. Okay. So basically, they're just going through here, and he's just going through and explaining what happened, which is matching up with what I remember hearing. And that is, this RAP program was created in January 2021 so that people could hear court hearings. And in particular, they said, listen, you don't need to get access to this Court Connect because you have access to the RAP, right? But then he goes on to say, on June 23rd, Britney made a statement in court during a hearing regarding the probate conservatorship over her person and estate. The court allowed the public and media to listen via RAP. The court warned that recording was prohibited. It did. The court became aware during the hearing that someone had recorded Ms. Spears' statement and advised, I understand there has been an issue with rap. Apparently somebody was recording the proceedings in violation of the order that I made this morning. So we're going to shut rap down right now. So please disable the rap immediately. That's also very concerning because I specifically said that there was not supposed to be any recordings, and that happened nonetheless. So I want counsel and Ms. Spears to be aware of that. So I made an order this morning that there's not to be any recording, and somebody, I don't know whether it's one person or more than one person, violated the order. The court has not identified who was responsible. It is unknown whether the recording occurred by someone on rap or LACC. The following day, the court eliminated rap. Okay, so let's stop right there. I know we're not like actually in the middle of a paragraph, but I do want to just stop here so we can consolidate where we are. So he's saying on June 23rd, Britney talked to the court and people were able to listen in through rap. Then the judge came on and said, I understand there's been an issue with rap. Apparently somebody was recording the proceedings and violated the order that I made this morning, so we're going to shut rap down right now. Christopher's argument I'm anticipating is about to be that was not appropriate because there was millions, thousands, whatever of people out here listening that were not recording. And so you took away their constitutional rights because of something somebody else did. He hasn't made that argument yet, but I'm anticipating that's where he is going. The court has not identified who's responsible. So he's saying, look, we don't even know who did it. And you're punishing all of us and taking away all of our First Amendment rights to be able to know what's going on in the court. The news release announced a general order rescinding social distancing requirements in all county courthouses and quoted the presiding judge that Court Connect will remain a staple of our court in the future, offering less expensive and convenient alternatives to in-person appearances. So the statement goes on to say, effective June 28th, the court is no longer going to have this RAP program to listen remotely. The court implemented this temporary program during the pandemic, recognizing there may be abuses of the court orders prohibiting recording, filming, and distribution of proceedings. Widespread breaches by the public in recent court proceeding, that's Britney, highlighted the need to return to in-person open courtroom proceedings, which is a welcome development. Oh, well, I see a problem here. Before I even get further on to what Chris is going to say, that's a problem. Because you've said that because it was easier for you, you're going to leave the LA Court Connect in place, right? Oh, that's a staple because it makes our life easier, right? But we're definitely not going to make the public's life easier because y'all don't matter. I mean, that's basically what I'm seeing. And so that does create a disparate impact and frankly, unequal protection. And also they put in italics here, Chris did, there would be abuses of the court orders prohibiting recording, and we put it in place anyway. We knew that in the beginning, and we still did it anyway. Well, yeah, and the remote audio of all cases in the state, too, indefinitely, isn't that extreme? Yeah, I mean, that's a good question, Gutter Star. Like, it's a bit extreme to say every single case in history needs to be broadcasted widely to the globe. Like, I don't think that's necessarily what we're trying to get at here. But this is a massive case of public interest. And I hope he argues that and really drives that point home that this isn't somebody's Aunt Betty in a conservatorship, which I think people should be able to know what's going on in court, period. But this is a case of extreme public interest, and it's a case where there's been a lot of media manipulation. So I would agree with Stephen's argument. Listen, I don't know about USA Today. I don't know nothing about them. They might be fake news. I really don't know. But I can only say what this man is arguing. It seems actually appropriate so far. So let's see what else. Okay. The statement acknowledges the court's prior assessment that the need for remote access outweighed the risk of recording. Okay. Yeah. So that's basically what I just said. The next hearing was July 14th, 2021. I was there. I know y'all are so tired of hearing me say that. There were 18 attorneys, parties, and interested persons on record for the hearing, including Bruce S. Ross, who is Vivian Lee-Thorin's former mentor, but then he was there on the 14th for Bessemer Trust Company, who was supposed to be an independent fiduciary. So y'all can sort that out. Okay. All of whom appeared via LACC or telephone per the transcript except for 3. This includes several participants who are not parties or counsel for a party, such as Amanda Goad via telephone, Zoe Brennan Crone by LACC, which is the Court Connect, attorneys for the ACLU of Southern California. I don't know what this sentence is, a little subject-verb agreement issue, but I think we get the gist. The ACLU was allowed remote access to the proceedings because it wanted to argue as amicus that Britney should be afforded the right to counsel. The court denied the proposal. The ACLU did not represent Britney, was not granted leave to appear as amicus curiae, and had no greater standing to participate than other members of the public. Ooh-hoo! All right, listen, he's making it harder to argue against him. The court also permitted a Kevin D. Cawley to use Court Connect, who is identified in the transcript as an attorney for an unidentified party of interest. And noted, Your Honor, is also talking about this. This Kevin D. Cawley guy, I don't know who he is, but apparently he represents people who are getting, having to defend their professional licenses. So, like, maybe he was there for Bridges to Recovery. Maybe he was there for, like, one of the lawyers, Vivian, I don't know, Samming, who knows? But he was there as an attorney for an unidentified party of interest. And we don't know what that means. There is intense interest in this case. Thank you. This is what I was hoping you were going to get into, Chris. With media outlets worldwide covering it, in-person attendance is not feasible for the media to cover the case. True. And that's what I was hoping he was going to argue, is that this isn't just like there's enough seats in the courtroom. This is something that, like, many members who do have a right to hear this of the public, they do have a right. And it's like, how are you going to just disconnect this remote hearing thing? Like, you have to give a reason. He says multiple requests have been made for media coverage from the beginning of this action, which have all been denied the same day. And maybe that's why this thing is so long. The next hearing is September 29th, 2021, and that could draw greater attention because of the ongoing allegations of conservatorship abuse by Britney and her pending request to remove Jamie as conservator of her estate. Reporters from outlets based outside of Los Angeles, like US Today, cannot easily send reporters to view the proceedings in person. And then he's referencing this Puente Declaration again. Relying on court transcripts or records is not adequate because of the delay in receiving those documents. Okay, good. He's already kind of coming for the counter arguments that he expects, right? He is expecting that the court is going to come back and say, well, there's transcripts and there's records in the court. Chris is saying, still not fair because there's such a long delay. It could take 2 weeks to obtain a transcript on a rush basis. Although court documents are usually posted by the next business day after filing, they are not a substitute for attending a proceeding. Agreed. Direct observation of the proceedings, whether in person or through remote means, allows the public and media to understand and report on the demeanor of witnesses and provide context to the proceedings. I agree completely. I've listened to them remotely. I've listened to them in the courtroom, and I've gotten information about them afterward. And I would agree that, like, there's no comparison to, like, seeing or hearing what went on in the courtroom as opposed to just reading something that may have typos and maybe 2 weeks later, right? On August 16th, the Judicial Council of California issued a report. Oh, wow. Okay, so this is just now, like literally this month. The Judicial Council of California issued a report on the importance of remote access, recommending that the courts expand and maximize remote access on a permanent basis for most court proceedings and should not roll back the increased access the courts made possible by remote technology to pandemic levels of in-person operations. So that's pretty bad, actually, for the that is pretty bad, actually, for the court, because the Judicial Council of California has come out and said, actually, like, we should expand remote access on a permanent basis for most court proceedings. So that's going to be really hard to argue against. Good find, Christopher. Per the report, remote access to the courts can increase equity, fairness, transparency for both the public and the media. Good. Oh, I didn't mean to make that green. That's supposed to be yellow. The need for remote access to the courts is likely to increase significantly in the coming months as California pursues more equity and inclusion initiatives and works to manage the anticipated rise and evictions. Okay, so there's a lot of different variables and factors going on right now that are going to make it better that there's more remote access, is basically what this report said. The benefits of remote access are discussed in the report. The reduction in the number of individuals who had to travel to courthouses reduced traffic and air pollution and will continue to have a positive climate impact going forward. Remote proceedings allow pro bono attorneys and legal aid providers to serve more clients with greater efficiency and increased transparency and access to court proceedings for the public and media. He's stopping the telephone game. Thank you, Britney Shane. Hear it firsthand and not by other parties where information can get changed, misheard from person to person. Exactly. I agree completely, Britney Shane, and thank you so much for the $5. That's so nice. Thank you. I have been spending quite a lot of money on these court documents, so it is very helpful. Thank you. So what Britney Shane is saying is, basically Chris is ending this whole he said, she said, what was said in court, what wasn't said in court thing. And if you remember, there was actually an account called Free Britney, what were they called? Hiatus Britney, not to be confused with the old Britney hiatus. That Hiatus Britney account was allegedly tweeting all kinds of lies, like during the court hearing, like, oh, Britney just said this and that. Britney just said all this stuff in the courtroom, and like none of it was true. And so it ended up being like a bunch of fake news we had to combat instead of talking about what Britney actually talked about. And for that reason, I think it's really, you're right, Britney Shane. He is stopping the game of telephone. Like if everyone can listen to it themselves and listen, that is why I started any accounts ever on social media for this stuff, because I know that once the public just has access to the information, they don't need anybody to tell them. Y'all don't need any lawyer telling y'all what happened. If you had access to 100% of these proceedings, you would already know what happened. And I agree with that completely. California courts should expand and so Judicial Council recommended that the California courts should expand and maximize remote access on a permanent basis for most proceedings and should not default to pre-pandemic levels of in-person operations. They also say the Judicial Council also said they encouraged and supported courts to expand, right? So make it even bigger, expand remote access through all available technology, and should work to promote consistency in remote access throughout the state to ensure. Okay. So basically, he's using like the Judicial Council's word against Brenda Penny. It couldn't have come in a more perfect time. So I'm very interested in to see, and maybe this is why this request hasn't been denied or accepted. Like he said earlier in this filing, usually when these requests are filed, they are denied on the same day. But this was filed on, it says October 29th on my heading up there, but that's a lie. I did the wrong date. It's actually the 26th. So it's been like 4 days and hasn't been denied, it hasn't been approved either or granted either. Thank you for spending your free time on this. Oh, thank you, Gabby, Nauru fan. Thank you for the $5 and the heart emoji. And thank you for coming here too. Okay. So what he's saying is he's going to hold this Judicial Council thing against Brenda Penny, and what good timing. Okay. So here's his discussion. This is like his legal argument. Okay. The First Amendment and the California Constitution provide a right for the public and media to attend non-confidential court proceedings. Okay, so this is where earlier Gutter Star, you were asking about what is his right to this. This is where he's going to get into what his right is. Why this is him saying like this is our standing to actually even give a crap about it, right? The First Amendment to the United States Constitution applies to the states through the 14th Amendment. And you should go watch my video about every time Britney Spears' rights were violated if you want to understand how the 5th and 14th work together. Provides that Congress shall make no law abridging the freedom of speech or of the press or the right of the people to peaceably assemble. The California Constitution, so that's the United States Constitution. So we're going to start with the big Mac Daddy of all the laws. Is like the highest law in the whole entire country. And then the second highest for any, individual as far as constitutions are concerned is going to be the one in your state. So the California Constitution also provides a more protective, definitive, and inclusive of rights to expression of speech. So basically, California's Constitution has come in and given citizens even more rights than the United States Constitution. So he's saying it isn't just this baseline level. Like basically like the safety net is the U.S. Constitution. And the safety net U.S. Constitution has said we have the right to this. But in California, it even goes a step further than the safety net, and you're going to be even higher up than this. It's a higher up safety net. And that one provides a more protective, definitive, and inclusive of rights expression of speech than its federal counterpart. And these are the 3 bullet points. The first one is a law cannot restrain the liberty of speech or press. The second bullet is people have the right to instruct their representatives, petition the government for redress of grievances, and assemble freely to consult for the common good. Okay, so we have the freedom to come together and consult each other for the common good. And the people have the right of access to information concerning the conduct of the people's business. Okay, boom. The people, that's like the citizens of California in this case, have the right of access to information concerning the conduct of their business, and therefore the meetings of public bodies, that's a court, and the writings of public officials and agencies should be open to public scrutiny. Okay, listen, this is all I really need to hear. Like, if that's what the California Constitution grants, then at least the people in California should be able to listen in remotely. I don't know, that's what I think. A qualified right of access exists for the public and media to attend certain governmental proceedings. This right extends beyond the context of criminal proceedings. So he's saying this isn't just crimes. Don't come over here and tell me it's just crimes. Okay, so now we have a civil procedure code, which is not going to be as powerful as the Constitution, but it's another law, right? And it mandates that hearings have to be open to the public. So this is a third different statute that's giving us the right to hear this, right? The Civil Code, Civil Procedure, Section 124, mandates hearings have to be open to the public except for certain proceedings under the Family Code or where state law allows closure. So they're saying like, okay, there's certain things that we're not supposed to be allowed to see under the Family Code and this other like catch-all for the state law. So what is he going to get into that? In this case, NBC subsidiary, the California Supreme Court, Chris rocks. Yeah, oh wait, is Chris in here? Chris, are you here? Oh my God. Thanks for doing such a great job of giving my brief. I'm a fan of your channel. Ha! Okay, everyone. Chris, the author of this brief that we're going over, has arrived. Now, Chris, I have to tell you, this is a fair and honest channel, so I've been questioning a few of your writings here, so you can answer. Not anything big. I'm just, whatever. I don't want people to think I'm being biased here, but a lot of times I just honestly don't know. I've only been having my law license for a little while. It's just like a think tank over here. Okay. So Chris uses this precedential case, NBC subsidiary. The California Supreme Court interpreted that particular statute we just talked about, holding that there's a First Amendment right of public and media access that applies to ordinary civil trials and proceedings. Now, I'm anticipating that Chris is about to say Britney's probate case is not a criminal case, but it kind of falls in line with these civil trials. The court in that precedential case, NBC subsidiary, did not address any right of access to particular proceedings because the case it considered was an ordinary civil action. Okay. Did not address any right of access to particular proceedings governed by specific statutes. Oh, because the court considered it an ordinary civil action. Okay, so in any ordinary civil action, so if it's an ordinary civil action, then it's open to the public. Like there has to be some special thing that takes it out of being ordinary, okay? Public and media access may be denied to special proceedings under that same code, right? 124, yeah. If provided by state law and the closure passes constitutional scrutiny. So do y'all remember we were talking about the test? It was like certain thresholds and certain like things you have to balance out before the court can take away your rights. So that's the constitutional scrutiny test. Under the historical tradition, utility consideration. So it's just this test. Y'all don't have to worry about what it's called. A law closing civil proceedings does not pass constitutional scrutiny unless the proceedings have historically been closed to the public and there is no utilitarian value in opening the proceedings to the public observation. Now, what I would argue, if I'm playing devil's advocate against Chris, is Britney's case hearings have historically been, okay, Siri, Relax. Okay, that was too much. Britney's cases have historically been closed to the public. So I'm hoping that he makes some kind of disambiguation here, or that he's going to say there is a utilitarian value in opening it up. So let's see what he's going to say. The test was used to invalidate former Family Code section 2024.6, which made financial disclosures in a divorce action non-public. Okay, so there was these people, they were getting married, and one of them didn't want their finances disclosed to the public. So what happened in that case? Divorce actions are open to the public, other than particular hearings or records that the family court may close per the authority granted by Family Code. In assessing whether a divorce action is an ordinary civil action for the presumption of openness under the First Amendment, that case in that divorce found that generally accepted divorces from California's... Okay, then hold on. Let me just read through this and see what this is. Berkeley Court found no case law that generally accepted divorces. Okay, so there was no case law in that case that was found to support the proposition that divorces are some special case, right? No, those are just ordinary civil cases like anything else. Okay, good finding. The court noted that the Family Code allows for the closure of certain family court proceedings, but it's obviously an exception and not the general rule in divorce cases. Okay, good rule to know. Nor was there any utility in keeping divorce actions quiet because the public has a right to know. The court concluded that the same First Amendment rights of access applicable in ordinary civil cases applies in divorce proceedings. Okay, so I think he's going to try and compare this case to a divorce case. Okay. One, probate conservatorship. Okay, so number one says probate conservatorships are generally governed by the rules for civil actions, and no statute authorizes closure of such proceedings. I hope this goes to the Supreme Court, to be honest. Like, I hope that this gets denied, and then y'all appeal it all the way up to the Supreme Court. And if you do, I'll probably be reading that one too. A probate court is one of general jurisdictions governed by the rules applicable to civil actions, except as provided in the code. Nothing in the chapter provides authority for the court to close a hearing. Okay, powerful. Powerful, Chris. He's saying the court don't even have authority to be doing this, so I don't know why they've been doing it. No statute makes probate conservatorship a confidential or special proceeding. Yes, thank you, Chris. I hope this goes to the Supreme Court, because this needs to be decided on a federal level. If y'all have watched Billy Mintz, The Guardians documentary, this happens all the time. The probate courts just get shut and the public isn't allowed to sit in there. We can't sit in there. We can't take notes. We can't ask questions. We can't do anything. Well, you shouldn't ask questions, but you know what I mean? Like, this should happen everywhere. If he's saying no statute makes a probate conservatorship a confidential or special proceeding, then that's very important. So people are asking Chris questions. Bye, Suzanne. Chris, could this be remedied? So people are asking Chris questions. And they're saying, could this be remedied and decided on in time for the next hearing? Okay, someone in this house is printing something, so probate is too powerful for no reason. They're sketchy. Okay, so someone's asking Chris a question. If he answers the questions, I will read the answers out loud. Okay. He's probably gone. Oh my gosh. Christina, was that a typo? Did you do that on purpose? Thank you so much. Oh my God. $99.99? That is so nice. Thank you. Is there a statute of limitations that can prevent Britney's counsel from filing criminal charges against Jamie and Lou Taylor? Well, the answer to that, Christina, and thank you again so much for the tip, is it depends. It depends what exactly which crimes they would be seeking to file. The issue, there's another issue too, which is you can file a criminal charge, as in, like, you can tell the police, you can file a police report, you can tell them that a law was broken. But the police or the DA or whatever has to actually make the choice. The district attorney has to make the decision to go through with that, right? So the statute of limitations question really is crime specific. So let's say that somebody was trying to go after them, some agency, for fraud. fraud might have a 6 to 10 year statute of limitations, where trafficking may have an unlimited one, right? So it would really depend, Christina, on what the statute of limitations for which crime, that each crime has its own statute of limitations. Sorry about this loud printer. Someone is printing like remotely from my printer. I'm hoping that it stops soon. Okay. The probate code envisions that, okay. That was so nice. Everyone tell Christina thank you for giving me $99.99 tip. That was so nice. I feel like that was a title. I feel like it was an accident or something. Okay, so let's get back into this. The probate code envisions that probate conservatorships will be handled openly, with notice to the conservatee and to the public, owing to the deprivation of liberty inherent in a conservatorship over a person or an estate. I honestly just want this to be the whole, could this just be the whole lawsuit? The probate code envisions that probate conservatorships will be handled openly and with notice to the conservatee, which Britney did not get, and to the public. Why? Because there is a huge deprivation of liberty inherent in a conservatorship over a person. Just inherent, like inextricably wound up with a probate conservatorship. It's necessarily the case that there is a stripping of your liberty. And for that reason, the probate code exists to allow for transparency and openness. So that's what Chris seems to be arguing here. The probate code recognizes the need to protect the rights of the people who are placed under the conservatorship, right? The court shall hear and determine the matter of establishment of the conservatorship according to the law and procedure relating to the trial. Notice of hearing, right? Britney did not get this. Notice of hearing is even required for most of the probate cases and proceedings. The law would not require public posting of probate court proceedings if the public was not invited to attend. Exactly, Christopher. This is common sense. And I always tell y'all, let's just apply common sense and logic, right? Why would the law say, oh, you have to give the public notice that a hearing is happening? Why would that exist if the public wasn't allowed to go to the hearing, right? Common sense. It's common sense. Sometimes lawyers just need to use common sense, and I'm so glad our friend Chris is doing it. Confidentiality is only required in probate conservatorship proceedings for medical records, court investigator reports, and information from some telecommunication system. Oh, the police system, I guess. Which I don't know why they got to be. Why is it got to be secret? What they doing? Confidentiality is only required in probate conservatorship proceedings for medical records, court investigator reports, and police records, basically from that electronic telecommunication system. It's obviously an exception to the general rule. The confidentiality of select records cannot justify closing of the entire proceeding, just as the court noted in that other case that he listed a while ago. I think what we're going to do is probably finish this out, and then we're going to call that part 1, just because I have a couple other things I have to do, but I'll do the rest of this if y'all really want to hear it. Otherwise, I'll just make this document available on my Google Drive thing on Twitter. So if you want these case documents, not all the ones, a lot of the cases that I bought, the documents are up on my Google Drive that's publicly available. Y'all can just go and look at it. It's on my Twitter bio. Okay. So he says, Code of Civil Procedures Section 166, Subdivision A, allows a judge in chambers to direct the issuance from the court of all writs and process necessary in the exercise of their powers, including a suspension of a conservator allowed by law. Hold on. I just want to make sure. Any argument? Okay. So Chris says there's another code, Section 166. So we already talked about 124. Now we're talking about 166. This allows a judge in its chambers to do all kinds of things, including suspend a conservator, right? These powers appear to be sort of administrative, allowing for signing an order in chambers without having to do so in open court, or in exceptional circumstances, maybe order the suspension of a conservator. But any argument that the Code of Civil Procedures Section 166 limits public access to probate proceedings is subject to the same, constitutional scrutiny that applies to 124. So he's he is anticipating another counter argument that perhaps Vivian or someone is going to use against him. That 166 mentions this thing about allowing a judge to do something in its chambers. Like, but Chris is saying, but that's just ministerial. That's just like administrative. Don't let them use that against you. No. He said nothing in 166 allows the court to conduct hearings privately or take evidence without notice or hearing. The probate court is prohibited from having ex parte communications. In the absence of a stipulation to the contrary between the parties, there shall be no... Okay. So basically he's saying not only is that not a good excuse to allow court, that is not only is using probate code 166 a bad excuse that is not actually going to allow, doesn't actually allow Judge Penny to clear the courtroom. In fact, 166 seems to stand for the proposition that she's not allowed to do that at all. Like, she's prohibited. She is prohibited from doing that. Prohibited from having ex parte communication. So basically, that's where we're going to stop here. We'll start the next one on this any closure historical tradition utility test, just because I'm starting to get a little fatigued and mind numbed. Thank you again so much, Monica. Thank you again so much, everyone who gave a tip. That was so nice. Chris, thank you for stopping by. Maybe we'll do a Chris Melcher, That Surprise Witness collab, and he can come on here on the next one. I don't know if he'll come. I mean, he came on Popcorn Planet, so maybe he will. But maybe he'll come and he can talk through this with us. I don't know. Unless y'all tell me, would you prefer me to go through it and kind of say each thing like, no, this is where I disagree with him? Does it seem like it's like less biased that way? Y'all give me your thoughts on that. In any event, I probably would still like to go live on like Instagram with Chris just in general, because he's cool and seems to be like in agreement with us on this like argument strain here. We are only on page, what are we here? 16 out of 244. Maybe the next video we'll take a detour down to Miss Puente's declaration, since that seems to be important, and then jump back into 2. But y'all let me know what y'all think about this content. Is it easier for y'all to do like super long, like a couple hours? I know like Emily D. Baker does like 3-hour long streams. Is it easier, more approachable and accessible for you to do like shorter, like hour-long ones? My whole entire point is making this information accessible and absorbable. So y'all just let me know, you know, what you think and stuff, but like while being nice, because if you're mean, I probably am not going to listen to you, even though I should, and that's not logical. But, you know, here I am being not logical on something. Thank y'all so much for coming here, and do one with others. I did recommend Sloan or Popcorn Planet. Yeah, I've done one with Popcorn Planet, and I should be doing something with Sloan pretty soon, once we like actually like link up. But okay, so I'm gonna go now. I'm gonna like try and figure out what this is that was printing from my printer. Who knows what that is all about. And thank y'all so much for hanging out. I've definitely plan on doing like at least one, if not like 2 or 3 of these a week. I don't want to like mess up the whole, you know, algorithm so that my stuff gets buried, but I really want to like get this information out as much as possible. I spend most of my waking hours like researching this case. So yeah, let's come back together and look through more of this later. Very, very interesting and unusual for a media request to be this long, but very thorough. And I do anticipate that if this is denied, they will probably be filing with federal court. Maybe that's one of the questions we can ask Chris if he does decide to join us at any time on one of these videos. So thank y'all so much for supporting the channel and coming here and subscribing and liking and all of that stuff. It really does make a huge difference to getting the information out there about the case. So I will be around and probably be doing a few collabs very soon, the next couple of days, and certainly the next weeks. And just remember, you know,